Chuck. Yeah. Chairman Huffsteller, thank you for being with us today. There is a sub prepared for your bill, but we'll certainly give you the time to speak. As
Okay. The sub, mine plus the bill is a complete sub. The bill we have is one dealing with the North Fulton Hospital operation, and so what we're doing is using yours as a vehicle for that purpose.
no.
Okay.
With
So-
that, Chairman Wheeler, do you want to present your sub?
Yes, so what we've got is, as Senator Huffsteller pointed out, we've got a bill that's his in the original form, which is Senate Bill 184. His dealt with a technical innovation that we're also considering in a House bill, so we think one of them may survive, showing that the medical information from various hospitals and health institutions can be acquired and used for research purposes. It gives direction to it. The bill we have here has replaced that bill, and the purpose of the bill is to talk about and deal with the establishment of a ambulatory surgery center, which is planned for North Fulton County in Alpharetta. And one of the main proponents of this bill is Representative Chuck Martin, who's here, and I'd like to have Mr. Martin come give us a little background information on this. Right
Chairman
here.
Martin, you can sit right here in front of us. Really,
Right here in front.
since you're confused, it seems like you're not spending enough time with us here in Judiciary. We're going good to have you with us.
I've had the opportunity to visit my friends in the Judiciary this year. Thank you, Mr. Chairman. I don't know. Let me do this at a high level, if it pleases the chair, and then I'll go into details as there are questions. There's a facility that wishes to get constructed in Alpharetta. I have a little information here because Legacy Sports Institute. Dr. James Andrews is lead doctor for that, and what they want to do at this facility is provide a holistic and an innovative campus to research not only the techniques for surgery, but the instruments they use, to refine the instruments they actually use to do orthopedic surgery. So back in September of 15, they made application for a certificate of need, and they were granted it, and then it was turned over by the hearing officer, and then the commissioner granted it again. It's turned back over. So over these last 2.5 years, they've gone back and forth when they're really just trying to build a facility that is innovative. Really would be, I can't think that there's one like it in the nation. And they're caught back and forth on a certificate of need. This is a copy of the original certificate of need that was granted for the project back in 15, September 25th. So what we're seeking to do in this bill, because I know it's a touchy subject, we've defined their project in the key line on line 14, medical research activities with physician training and education in sports medicine, so that they have a holistic idea. One thing I'd like the committee to entertain, if they would, is on line 24. It says, and I think this has been put in bills before, that they would do an amount equal to or greater than 3% of their adjusted gross income in indigent care. We'd like you to, if the committee would consider changing that today, we'd like you to consider changing that to 5%. That was what they had requested and had been called for in the original certificate of need, and Dr. Andrews and the firm, that the folks that are working on this would be more than happy to participate in the community. They want to build up a facility to provide, leading edge, cutting edge. I guess that's a bad term to use in surgery, cutting edge, but leading edge innovations and research. And we really feel like this is a special facility, a special process with the quality of care where Dr. Andrews has done hundreds of Tommy John surgeries. I'm not familiar that there are a lot of doctors that do those in other places, that he would be able to provide that type of surgery here at this facility and train other doctors to do it at the highest level. We think it's very special, And normally when people are coming to us, they're asking us to help them with a tax break or something to build this kind of facility. And all these folks would like to do is, have the original certificate of need that was delivered in September 25, allow them to open, build, and invest in the state of Georgia.
Any questions for Chairman Martin? Chairman Caldwell.
Chairman, if you got a CON, why has that been reversed, or what's happened with it?
Well, Your Honor, or your lawyerness, if you will, I'm sure it's judges have found technical flaws. They've basically said under Rule 111, paragraph 3B, in the CON rules, the department is allowed to make an exception to this need standard for an atypical barrier. And the original CON was granted, saying they met that, and it was overturned by a hearing officer. The commissioner reaffirmed they had met that, and then it was overturned by a Superior Court judge. So with due respect to the hearing officer and the judge, I think the commissioner of the Department of Community Health is probably in a better position to understand, if they meet the rules that the department puts forward, than a judge. Now, I'm not a judge and didn't stay at the Holiday Inn last night, so I mean no disrespect to the robe and the people that sit there, but I think you bring up an excellent point. Given the fact that they were granted it twice, is the reason we're seeking legislative relief, so they can go ahead and build it and make this investment. Had it not happened before, they would have been in a place where they would be probably well on the way to opening and giving Georgia the highest, in innovative healthcare and surgery.
Yeah, follow up, Mr. Chairman.
Yes, sir.
The understanding I have about the Superior Court matter was that there was a procedural question about the appeal, which serves like a writ of certiorari appeal from that hearing officer and the commissioner's decision up to the Superior Court, and there was faulty in that regard. The reason of the reversal, not based upon the merits of it,
Yes, sir.
but on that part of not having been correctly processed to the Superior Court. Is that right?
That's my understanding, but as I said, I'm not,
Yeah.
several semesters shy of a law degree, so thank you for the help in that, Chairman Weller.
Representative Stevenson.
Chairman Willard answered one part of it. Who bought the appeal? I understood that it was turned, but what entity bought it?
The challenge, the certificate of need was challenged after it was issued by Northside. I mean, I've got a list: Northside Hospital Incorporated, doing business as Northside Hospital Atlanta, Northside Cherokee, Northside Forsyth, Northside Alfreda Surgery Center, North Fulton, and then several of those, or at least two of those, withdrew their appeal. Emory Clinic, doing business as Emory Orthopedic and Spine, withdrew their appeal. Yes, sir. Competitors.
I don't see any other questions for Chairman Martin. Jordan, did we have a sign-up sheet? Anybody that wants to speak to the measure? Yeah, I know
Yeah.
some people have came in since we started the meeting. If Tim, if you just want to go in and just going up there, and as we'll take this, y'all can just sure can. You can go sit in the corner, certainly.
Thank you, Mr. Chairman. My name is Tim Kibler. I'm with the Georgia Alliance of Community Hospitals. Wellstar, Northside are both members of ours, two of the objectors in the case. Our organization has reviewed Chairman Martin's original bill, and we are very much opposed to it. I understand some changes have been offered. If they are reflective of what was shared with me yesterday by some of the advocates for this legislation, we are still in opposition to it, and would ask you to hold off on moving it forward at this time. If I may back up, and I apologize, Mr. Chairman, I don't recall if you were involved in the 2008 CON reform bill or not. But that was an extensive process. Yes, sir. That was an extensive process that reviewed the certificate need within the state of Georgia. And what they determined was that to allow multi-specialty and exemption from the certificate need process was the thing that would most likely, most significantly harm Georgia's hospital community. And while I'm confident that's not Chairman Martin's intent, it is our concern that in fact that is what would result as a result of a version of this moving forward. I think that you'll hear more about the status of the case from others. I, like Chairman Martin, am not an attorney, but do have some level of understanding about what's going on so far. And it is my understanding that there is the Supreme Court has not ruled ultimately on this, that the appeal has been made from the Court of Appeals. We would ask you again to hold off. The Rural Development Council is going to review the entire certificate of need process this summer, and we would encourage this committee to both allow the court, the judicial process to unfold, and to consider any changes within the context of the entire certificate need process, rather than this proposal to assist one institution and group.
All right, Chairman Fleming.
So Tim, you agree this only helps one group?
It's my understanding that's the intent of it, Mr. Chairman. I don't know that I've seen the substitute that you're working from, so I couldn't say authoritatively. But it's my understanding that's the intent.
You saw the original bill though, right?
Yes. Yes, sir. Which?
The original bill's the same? Can Chuck say something?
Yeah, if I might, the substitute further closes the thing and specifically says on line 11, a single specialty neuromuscular facility. What is at issue here? And I think
So the answer is that your original bill only affected one entity, and you've narrowed it even further. So we're definitely only affecting one entity.
Yeah, yes, sir.
That's all I want to know.
Yes, sir.
Any further questions?
If I might also, and again, I know the chair's ready to move on, but I would give this committee, and if we get this to rules in the whole house, this will not turn into a vehicle that would turn into COM reform. I would not accept any additional carriers, any trailers, if you will, on the bill. If so, we would just let the bill lie and let the bill die. I've let the folks that are advocating for the bill know that this will not turn into extra. Yes, sir. But I mean, things can go to conference or whatever. My commitment to you and to others that are worried about it becoming something else is, I've been down here for a little while, and I understand that you have one chance to keep your word, and this would not become something that is not that other than what you see on the paper today.
Any other questions for Tim? All right, thank you, Tim, for being here with us. As other members of the audience that want to testify, Ethan.
Mr. Chairman, please, I'd like to be joined by Kerry Conley, who's our Associate General Counsel.
Absolutely.
Thank you, Chairman Kelly, members of the committee. I'm Ethan James with the Georgia Hospital Association. And, we have discussed various provisions of this legislation, both in a Senate committee and in a House committee previously, and we still stand in vehement objection to these provisions. The CON process, of course, as you know, we've discussed in this committee, I believe, as well, is very important to our hospital community. We know it is being looked at this summer by the Rural Development Council, as Mr. Kibler stated. But with that, I'd like to turn this over to Kerry Conley to talk about some of the provisions of this bill that do give us some concerns. Thank you.
Thank you, Ethan. Mr. Chairman, members of the committee. Before we get into the merits of the particular bill, we do need to talk about the timing issue. In addition to the study that is going to go on over the summer, This issue is still in active litigation. There were Supreme Court filings as late as last week involving this case, and it seems to me a pretty clear attempt to either be bypassing or interfering in the judicial process to come at this point in time to try to get an exemption to impact just one surgery center. And, you know, it sets a potentially dangerous precedent, not just related to the administrative process around the Certificate of Need program, but with any administrative appeal, that once you get into the courts, if you don't like the way it's going, you just come down here and ask for an exemption or a change in the law while that case is still pending. So I would ask this committee to consider that in particular as we're thinking about this legislation. Some of the other issues, and you know, I know that this committee in particular doesn't necessarily deal with the Certificate of Need program on a regular basis, so I'm happy to answer any questions about how it works or why it's important. But before we get into that, a few other facts about this particular proposed surgery center could, if the proponents so desired, already qualify for a CON exemption under the 2008 legislation that allows for single specialty ambulatory surgery centers to be exempt from the law, or they could work with any of the number of surgery centers that are located in and around the Alpharetta area where this center proposes to be built. And I'm happy to answer any questions about CON, why it's important.
Thank you, Mr. Chairman. We'll be happy to answer any questions about CON.
All right. Thank y'all. Chairman Fleming, do you have a question?
So procedurally, and Mr. Chairman, you mentioned this. Initially, the CON was approved, correct? By who?
I believe by the Department of Community Health.
Correct.
And then it was appealed to a hearing officer.
Correct.
The hearing officer reversed.
Yes.
Then it was appealed to the commissioner. The commissioner sustained the grant.
Right.
Correct.
Then it went to where?
It went to the Superior Court.
Superior Court agreed with the hearing officer.
Correct.
Then it's on appeal now to where?
Then it went to the Court of Appeals.
Right.
The Court of Appeals agreed with the Superior Court, and now it is on appeal to the Supreme Court of Georgia.
So you mentioned earlier something about us interfering with the judicial process. You want to explain that to me?
Well, it to me sets a dangerous precedent for any time. There is a very specific administrative appeal process that is laid out in the Certificate of Need statute that essentially it has some differences, but essentially mirrors the process that's laid out in our Administrative Procedures Act, which allows both proponents and opponents of a Certificate of Need to appeal up to the Georgia Supreme Court. And we haven't let that play out in this case. We don't know how the court is going to rule, and in fact, it's Legacy that has filed the appeal with the Georgia Supreme Court.
You would agree with me, though, that except for constitutional matters, the greatest appeal is to this legislative body because we create the law and decide what it is.
Yes, absolutely.
Thank
Absolutely.
you. Thank you.
Any other questions for the presenters? All right, seeing none. Thank you,
Thank you,
for
Mr.
being
Chairman.
with
Thank
us.
you, Committee.
Any others that who may have been inspired through testimony today to or the presentation to speak before us? All right, Chairman Willard.
Well, let me close out before we have motions of might, Mr. Chairman. I think what you hear about in this case is one of what I felt has been a continuing problem in the state's regulations in the medical fields as to specialized needs type hospital facilities, surgical facilities, which are dealing with, in this case, Dr. Anderson, who's a well-known physician in the area of sports medicine and surgery. He's done hundreds of Tommy John surgeries. The reason he is looking to try to locate here in Atlanta is to have access means through our great transportation system locally to get parties in and out. He specializes only in the area of sports type medicine. The thing you're also hearing, which is I think a continuing problem, is the only ones who are benefiting, and I say this as a lawyer, is primarily the lawyers in this area of work, because we're spending, as parties seek to get approval of a certificate of need, hundreds of thousands of dollars unnecessarily in the area of trying to provide medical services to the citizens of our state. The federal government initiated this program of certificate of needs back in the early 70s. Many states, of course, by virtue of what the federal government was mandating, adopted certificate of need legislation. The federal government realized several years later that this was really a mistake, because it's really a controlling of making decisions who are winners and losers in the field of medical care and services being provided. The federal government pulled back from this. Many states have also recognized their regulations were far extreme to the need of the people of the state. A number of states have either totally done away with it or have substantially modified their certificate of need. Georgia has very, very reluctantly, because of the strong groups of lobbyists in the field of medicine, taken a very different approach. It's been difficult, especially recognizing in the metropolitan area, as Atlanta is, to have this available for our citizens on a need basis. As we say, we think the market should really bear the determination in these type of facilities, who is going to put the facility in and who's not. The right to have a business is something that should address the free market, shall we say. Even the committee was set up to study the needs in rural areas this past summer by the House. Found that there was a need probably to modify the certificate of need program in the metro areas and have it perhaps available to be a saving benefit for rural areas because of the hospitals folding up in those areas. That may be the case. That issue was abandoned for whatever reason as far as legislation coming forward this year. Yes, I've been a proponent of changes in CON for several years. Yes, back in 2008, I was aware that some changes made. That was 10 years ago. That's still being argued. Well, there was an agreement made that was made with one particular hospital. It wasn't made with the 36 legislators. It was made with the hospital that was the cancer treatment hospital outside of Noonan. This is, to me, this very much the type of thing that is needed in Georgia, because it's a specialized type of surgical facility. And I would hope that the committee would provide support for it, so at least we have it go forward and see if it's something that the House as a body can consider on a vote before the full House before adjournment. I would ask for support of the members of the committee on this. Thank you.
Thank you, Mr. Chairman. I'm going to give Chairman Martin a chance to close before.
Thank you, Mr. Chairman and committee members. Look, the CON process is a big thing out there, and they're going to study this. What we're talking about here, actually, the learned attorney with the Hospital Association probably made my best point for moving forward with the bill. There's probably hundreds of thousands of dollars, millions of dollars that go into going through a CON process and going through this court costs, as Chairman Will just said, for legal costs. If Dr. Andrews felt like he could have done this, could have done all the research that he wishes to do with it, do all the teaching that he wishes to do with it, do all the innovation for the medical devices that they wish to work on and provide with an existing facility, don't you think they would have done it? They make my point when he couldn't do that with an existing facility, that this is atypical, which is what the department found on page 8 of the grant. On the atypical findings in the paragraph 3B, I believe it is, the criteria for this rule are met by the proposed development. This is what our Department of Community Health has said. So we're not asking to be relieved of CON. We're asking for this to be upheld. They have all of the other items in the rules that they need to meet have either been met or don't apply in the application that I have here and has been approved. So respectfully, this meets the criteria that should have been granted, was granted, should have been upheld, and we can fix it today as a legislator. We can start the process of fixing it today in this committee, and all I'm asking for is the opportunity to take it forward in rules and let the will of the House be heard. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. We've heard testimony and plenty of debate. So we'll now take the bills now before the committee. What's the committee's pleasure? We have a motion, do pass. Do we have a second? We have a motion and we have a second. Any discussion or amendments? You're certainly recognized for that.
Thank you. On the line 24, rather than the 3%, I would amend 3% to 5%.
We have a motion and we have a second. Any discussion about Chairman Willard's proposed amendment? Hearing none, we'll now call the question on the amendment. All those in favor of the Willard amendment on line 24, make it be known by saying aye.
Aye.
All opposed, like sign. The amendment passes. Any further amendments? All right, the bill is now before the committee. The motion is due pass by House Committee Substitute as amended LC 337451S. All those in favor of the motion make me known by saying aye. Aye. All opposed, like sign. The ayes have it. Bill moves to rules.